standards in providing protection and benefits to workers. On the other hand, employment conditions in Denmark, as in other Nordic countries, are generally good, since the labor sector in these countries are governed by comprehensive laws, rules, regulation, which ensure that mechanisms are in place to address workers' concerns and basic human rights. Labor unions are also strong in these countries, ensuring that the rights of workers are promoted and protected at all times. National labor laws of Denmark reflect many of the central features of the so-called Nordic model of industrial relations and generally provide sufficient protection for all workers regardless of citizenship or immigration status. The labor market in Denmark is characterized by a high level of organization on both the employee and the employer side, with collective bargaining playing an important role in setting minimum wage, compensation packages, benefits, and other labor and social legislation. It is noteworthy, Madam Chair, that in the case of Denmark, OFWs and even permanent migrants have suggested the negotiation of a social security agreement. Filipinos in Denmark have requested the Philippine government to initiate social security agreement negotiation with their states of employment.
Please excuse me. So we're discussing both countries simultaneously,
Yes,
aren't we?
Madam Chair.
Portugal and Denmark.
Yes.
Would you say that basically the agreements are the same?
Yes, Your
With the
Honor,
two countries.
essentially the same.
All right. Please proceed.
Negotiating social security agreements with more states of employment is a high priority for the Philippine government in anticipation of the retirement of OFWs who started working abroad more than 30 years ago. And a steady flow of retirees is expected to follow as a result of the growth in the number of migrant workers over the years. Due to existing social security agreements, many OFWs can enjoy their retirement upon they return to the Philippines because their benefits, such as their pension, will not be stopped. So, for this reason, Madam Chair, again, may I respectfully endorse the concurrence of the Senate for the ratification of these two agreements. Thank
May
you.
I just put this very briefly? There are two countries involved, either Philippines and Portugal on the one hand, and then Philippines and Denmark on the other hand. But in both cases, in both countries, the arrangement simply is administrative. So it's not, one of those earth-shaking treaties that affects the entire foreign relations policy of the country. It's simply to help them administratively. It's just an administrative treaty, so that, for example, if a Filipino worked first in the Philippines and earned social security credits, and then transfers to another country and does a job similar to what he did in the Philippines, when they, in effect, the sum total of his social security credits, they will involve the credits for him in both countries. We acknowledge the presence of Senator Ferdinand Marcos Jr., thus making up our quorum.
Good morning, Madam Chair.
And this applies, for example, in the computation of pensions, other benefits, disability benefits, for example, and so on. It's simply to avoid any undue discrimination against overseas workers. Would you say that's a fair statement?
Totally agree, Your Honor.
Okay. All right. Is there any oppositor to this treaty? The two treaties with Portugal and Denmark for social security arrangements? None. Thank you very much, Ms. Secretary.
Thank you, Your Honor.
And you are excused, but where is this other person, POEA Administrator Hans Leo Kakdak? No, he cannot be on his way. You have jurisdiction over this person, don't you?
Yes, Madam Chair, POA is an attached agency of the DOL.
Yes.
And
will you please promise to punish this person for being late?
Actually,
I am serious.
Actually, Madam Chair, in the preparation of the statement that I just presented, we collaborated.
I know that. You would probably collaborate with someone else.
Yeah.
But still, he must not make the Senate wait. The Senate is a collegial body, separate and distinct from every single senator. Will you please tell him not to repeat this at greater pain to himself?
I'm very sure, Madam Chair, that he will sincerely apologize for
He better
not being
do that.
here. Thank you, Madam Chair. Thank you, Senator. Senator Marcos.
Now let us go on. After the social security arrangements with the two countries, let us go on to what?
Ito po yung kompleto na yung resource persons. Other treaties po, wala pa po yung iba.
Let us go to the Montreal Convention for the Unification of Certain Rules for International Carriage, also known as the MC99. Our resource person will be headed, resource team will be headed by DOTC Undersecretary Jose Perpetuo Lutilia. Undersecretary Lutilia.
To leave, Your Honor.
Yes, you're excused. Thank you.
Ask permission to leave, Your Honor.
Yes. Where is Mr. Lutilia? Who are you? Are you Arcelia?
Ma'am, Yusek Lotilia po.
To M. Lotilia, Madam Chair.
You look different from the person who was formerly my student. Are there two persons with the same names?
Madam Chair, my name is Jose Perpetuo, Madam Chair.
What is the name of that other person? Rafael.
Professor Rafael Perpetuo Lotilia is my
Are
brother.
you related? Oh, I
Is my
see.
brother, Madam
Okay,
Chair.
welcome to this hearing. And then is the cab director here, Carmelo Arcelia? All right, take a seat beside your boss. We are going to discuss what is called MC99 or 1999 Montreal Convention for the Unification of Certain Rules for International Carriage. Actually, it means the agreement among all the airplane flying countries of the world on how much should be paid to a person if, for example, he gets injured or dies during a flight, or if he loses or suffers a claim in his baggage. No? So this should be interesting to the majority of our listeners today. Go ahead and make your statement.
Thank you, Madam Chair. Good morning to the Honorable Senator Ferdinand Marcos Jr. of the Senate Foreign Relations Committee. Madam Chair, thank you for this opportunity to present the side of the Department of Transportation with respect to the concurrence of the Senate on the ratification of the Montreal Convention on the carriage of passengers and goods by air. The Department, Madam Chair, respectfully endorses the concurrence by the Senate to the Montreal Convention. The Montreal Convention is an improvement and a codification of the rules regarding the carriage of passengers and cargo by civil aviation. This is a codification which follows and effectively supersedes the 1929 Warsaw Convention, which was subsequently amended by the Hague Amendment.
Lumang-luma na yung Warsaw Convention, no? Isn't
Yes.
the Warsaw Convention, that which is printed in very fine print at the back of the ticket that is issued to every passenger? Normally, we don't read them anymore, no? But what is the significance of the Warsaw Convention, which is still used in Philippine airplanes?
Madam Chair,
Bakit napaka-importante niyang maliliit na yan?
Madam Chair, because it sets out the
Limits.
liability po of the
Yes.
carrier.
Kung mamatay ka at nakasakay ka sa aeroplano ko, ganito ang ibabayad ko sa iyo. Kung nasaktan ka o nawala ang bagahe mo o na-delay ang bagahe mo at merong perwisyong nangyari sa iyo, no? Hindi tayo nagbabasa niyan. But that is part of our contract with the airline. Now we want to change that contract at the back from the Warsaw Convention to the Montreal Convention. Now tell me, what are the features of the Montreal Convention?
Madam Chair, the Montreal Convention actually creates a new paradigm for liability on the part of the carrier. because in the Warsaw Convention, Madam Chair, the basis for liability was fault or negligence, and that had to be proven. So because of the advances in civil aviation, it was deemed that the basis for liability should no longer be through a prolonged litigation to prove fault or negligence on the part of the carrier, but rather it should be aligned to the modern concept that a carrier or in Philippine civil law parlance, a common carrier would be liable upon breach of the so-called contract of carriage. And
Okay. Will you please make a comparative study for us between the Warsaw and the MC Convention? O sabihin mo sa akin, kung may nawala ka o may nangyari sa iyo, anong total na pwede mong matanggap sa Montreal Convention? Anong total mo?
Madam Chair,
Ilang dolyar?
sa Montreal Convention, it's around 1,173 SDRs,
Or-
special drawing rights.
Special drawing rights is just a legal fiction, no? It does not really exist. But it's supposed to set the standard for the currency that is involved. You translate it by multiplying it or dividing it by the currency involved, no? But in our own case, since we are attached to the US dollar, it appears that Montreal Convention will give as much as $175,800, no? Isn't that so? That's the equivalent of those SDRs that you mentioned.
Madam Chair, I have not actually computed the
Yes, it
present exchange rate. Madam
Ngayon,
Chair.
if there is no negligence or fault on the part of the airline, pwede ka magtanggap ng SDR, special drawing rights of 100,000. So that is actually the basis of our work today. We want to know whether we want to impose these additional penalties or whatever you might call them on the airline, or we'll just get stuck with Warsaw Convention, mas murang pabayaran nila. Kaya, alin ang mas maganda para sa publiko dyan? Warsaw or Montreal?
Para po sa ating mga pasahero po, it's
Yeah.
The Montreal Convention.
That's
po.
right. So that is the main reason why we want to concur with the ratification of the Montreal Convention so that Filipinos who travel a lot because of the overseas workers may avail of these higher amounts if something happens to them or to their baggage, no? Please proceed.
This, the Montreal Convention po, in effect, does away with having to litigate and establish negligence or fault on the part of the carrier. It is just based on the fact that there was a contract that the person boarded this particular flight from one state to another state. And once there is injury or death on the part of the passenger, then that passenger has the right to claim the rights under the Montreal Convention without need of having to prove negligence or fault on the part of the operating carrier. This was not the case with respect to the Warsaw Convention, because under the Warsaw Convention, the basis for liability was proof of negligence or fault on the part of the carrier. So from a domestic law standpoint, our analogy would be that the Montreal Convention is aligned to the concept of a higher degree of diligence required for common carriers under Philippine law. Because under Philippine law, the mere breach of the contract of carriage is sufficient to attach liability to the carrier. Now, it's just, of course, it is not as strict as Philippine law where it says that the required diligence is extraordinary diligence on the part of the common carrier. But then, because of the concept that liability attaches upon the person or the cargo being loaded aboard the aircraft of that carrier, then it is almost akin to that Philippine concept of liability because of contract and without need of proving negligence or fault on the part of the carrier. Now, in addition to this basic concept of liability, the Montreal Convention allows the use of modern methods of, for instance, issuing tickets or issuing airway bills, because under the Montreal Convention, there is now a recognition that there could, for instance, be multiple carriers that will be carrying cargo or passengers, and the convention spells out the rules by which liability will be shared by and among those carriers that transport the cargo or the person from one state to another. This was not, of course, present in the Warsaw Convention, because in the Warsaw Convention, this was in 1929, these concepts were still not yet present at the time.
Ang luma-luma na ng Warsaw Convention hanggang ngayon hindi natin napapalitan ano some how do you say in Tagalog? In other words, it's overdue actually. So let us summarize. Under Warsaw Convention, if something happens to the passenger, his limit is $24,000 US. But under the Montreal Convention which we are discussing, his limit will now be raised to $170,000 US. So, mas magaling para sa pasahero. Plus, with respect to luggage, dati, ang luggage per piece, ngayon per passenger na. Dati, sa ngayon, if something happens to the luggage, the maximum that the passenger can get from the airline is $1,500 in round figures. So, mas magaling lang talaga. Ano kayang masama dito para sa atin?
There was some discussion, Madam Chair, that with respect, for instance, to the carriers, that they could have, in effect, a higher degree of liability. So it also affects our domestic carriers, Madam Chair. However, I think on further consideration, Madam Chair, carriers, anyway, take out insurance to precisely cover for the risks associated with civil aviation. So it is not exactly a real problem. And besides, in terms of the so-called damages that they can claim from the airline, there is still a requirement that there must be proof of the quantum of damage that has been suffered by the particular passenger, although there is no need to prove fault or negligence.
Anything else?
Madam Chair, I believe that there are no other, shall we say, negative points regarding this.
What about the CAB Executive Director, Carmelo Arcilla? The Civil Aeronautics Board.
Good morning, Madam Chair, Your Honor, and to Honorable Senator Ferdinand Marcos Jr. Thank you for inviting us to participate in this discussion. And if I can just add to the statement of Undersecretary Rutilia, the CAB concurs with the position taken by the DOTC, and we find the provisions of the Montreal Convention as updating and modernizing the patchwork of, because the Warsaw system is actually a patchwork of liability regimes that started in 1929. The Warsaw Convention became effective in 1933, and then it was amended and supplemented by the Hague Protocol in 1955, and then there was a series of the Guatemala Protocol and then the Montreal Additional Protocols, 1, 2, 3, and 4. So it's a patchwork of liability regimes which the Montreal Convention seeks to consolidate and make less confusing. And Madam Chair, what we find in this convention, the Montreal Convention, is that it is more customer or passenger centered, in the sense that it not only increases the liability, but it provides for a two-tiered kind of regime, liability regime. And I think the crucial point there is the first tier does not require that the proof of fault is established by the claimant, because the fault is presumed, unlike in the Warsaw Convention, where there's a defense available for their carrier that they exercised due diligence. Another point, Madam Chair, is the fact that it also makes more flexible the option of the claimant in terms of the jurisdiction, because it expands the jurisdiction in terms of the venue. It adds one additional, they call it the fifth jurisdiction, whereby a claimant can file his or her claim in the jurisdiction of his or her permanent or principal residence. So this gives, in the case of Filipinos, they would not need to go to a foreign land to file their claims. And also, it takes stock of the modern nuances, like the advances in technology. Nowadays, we have code sharing, so it provides for joint liability between or among code share partners. It takes stock of the electronic advances. Nowadays, we have electronic tickets, and this is not covered by the Warsaw Convention. So, thank you.
Let me raise this question. Suppose you file a case here on the basis of the Montreal Convention, but the airline belongs to a state or flies the flag of a state that has not acceded to the Montreal Convention. How will the judge decide the point of jurisdiction?
In the literature, Madam Chair, that I have read, then the Montreal Convention will not be applicable, because it is required that the other country, the partner state, should also be a signatory to the Montreal Convention.
Then that international system would be rewarding the renegade. Everyone else is agreeing to behavior or a best practice or good behavior, as in this case, increasing the amount to be paid to the passenger for whatever claims he might be making. But one party, let us say one state, does not wish to accede to this arrangement, and it just refuses to participate. What is the remedy of the international community? Otherwise, we'll just be allowing the renegade or the rogue state, which doesn't want to observe the modes of procedure accepted by the others, to get away with this fault or his refusal.
Thank you, Madam Chair. The goal of the ICAO is to have this universally accepted. Today, there are about 111 signatories to the convention. And in the event that one country would be reticent or would really be refusing to accede to this, then in my mind, Madam Chair, then the market will punish that country, because if it is not in the flow of things in global aviation, it will be left out in the code. That's how I look at it, Madam Chair.
What are the realities of international relations? It's all very well to fiddle with all of these words and what they mean in the technical sense, but in reality, it will become a question of how powerful the renegade state is, as is happening right now in the case of the Ukraine and Russia. You can argue until you are blue in the face about the moral position of Ukraine, but Russia is so powerful. She's about, at this time, even up to this time, she's able to stand up to all the persons allied against her. Now, let us go, for the same two resource persons, to the protocol. A protocol means an addition or a supplement, normally in the form of a significant rule or regulation. So we've just studied the Montreal Convention. We have agreed that it is worthwhile for the government to concur with it. Now let us go to the protocol amending Article 3 bis, meaning to say the entire Article 3 with its paragraph A, B, C, of the Chicago Convention on International Civil Aviation, Remember that the Montreal Convention seeks to raise the limits of how much an airline should pay a passenger. Now we have a protocol which, and I have to read this, quote, recognizes that every state must refrain from resorting to the use of weapons against civil aircraft in flight, and that in case of interception, the lives of persons on board and the safety of aircraft must not be endangered. Undersecretary Lutilla, your statement, please.
Madam Chair, the department respectfully endorses the concurrence by the Honorable Senate, Madam Chair, for the protocol signed protocol to the Montreal Convention, amending Article 3 bis of the Chicago Convention. Since this particular protocol, Madam Chair, is actually a recognition of the internationally recognized principles today relating to civil aviation, that it is a basic principle that weapons should not be used against civilian aircraft that are being covered by the Chicago Convention. And in the particular instance where the civil aircraft overflies the territory of a state without authorization, the state has the power under the protocol to require the intruding aircraft to land at a designated airport. And this right of the state holds true also if the civil aircraft is suspected by the state to be flying over its territory despite having the necessary authorization, but is being used for purposes contrary to the purposes of the Chicago Convention. So this is a principle that the state itself can then exercise its right of self-defense and therefore require the aircraft to land at a designated airport by the state.
Actually, this matter has already been addressed by our own domestic law, the anti-hijacking law. If there is equipment or weapons, if the passenger is weaponized and the state over which the plane is flying discovers this contingency, that state has the power to order the plane to land immediately. Naturally, the hijacker will make sure that the plane will not land. What then will be the remedy for the civilian passengers? Ano ngayon ang magagawa if he points his gun at the temple of the pilot and says, don't land?
Madam Chair, I can only recall, I think, that particular aircraft that crashed outside, I believe, around the area of Virginia, Madam Chair, in the 9/11 incident, where I understand, and the subsequent reports show that the passengers themselves sought to overpower the hijacker, but in the process, however, the attempt was too late, and the aircraft still crashed, but far from a populated area, which was actually the target of the hijacker.
Do you know of any particular movement or development towards forms of transportation other than by plane or by ship? By plane, transportation by plane seems to be increasingly dangerous these days. Look at what happened to all those planes that went missing, and then they drew the conclusion that it had crashed into the sea. So everyone died without any exception. Is there no system of, let's say, teleportation that is being developed?
Madam Chair, I'm afraid
or some other form of transportation? I don't want to travel with someone who's a hijacker, of course. No?
Madam Chair, as far as I know, it is still in
okay.
the realm of possibility.
In the realm of science fiction. All right. So this is, actually, you don't even have to bother to implement this protocol because we've already passed our own law for it. Is there any opposition to these two airline protocols? If not, thank you very much, gentlemen. You're excused.
Thank you very much, Madam Chair.
Let me call the
thank you,
people
Madam
for the
Chair, Your Honor.
PEMC. PEMC headquarters agreement.
Hi, Senator. Good morning. I think you were looking for me.
Yeah, I was.
That's Juju, my elder brother. Yeah, Senator. Yeah.
Hello, good morning.
Yeah, I used to be the PEMC executive director, so that's why I'm
that's
just.
what I have in my
I'm just,
notes. Now,
yes.
what are you now?
Right now, in effect, I'm on sabbatical. So I'm with the Philippine Center for Economic Development
Oh,
in the UP School of Economics.
ay. Edi, mag-resume ka na. Mag-headquarter ka.
Yeah, Secretary Paez.
Thank you. Thanks very much. Dalawa na lang.
Ang bilis ko. That's
Kasi-
why I actually made
Just ask them leading questions. Isn't that so? Isn't that so? Kala ka naman sabihin.
medyo na-throw sila dun sa teleportation. That was a little out of left field.
I always enjoy it when I am bumped off, or not really enjoy, but I'm always excited when I'm bumped off or my luggage did not arrive.
Why?
Because I always win these cases.
Oh, well, of
I
course.
usually sue,
I know, but what a nuisance. My gosh,
but they will settle. If you prove that you are serious,
Oo.
like for example me, pag pre-trial conference, mag-attend talaga ako.
Well, I had Alitalia once buy me a whole set of clothes because they completely lost my luggage.
Oo.
But in the meantime, until I got my set of clothes,
It was an
it was a
inconvenience.
real inconvenience.
Right.
It happened to be winter. And I
Ay, sayang,
I had
winter
come from the
clothes mo.
Philippines.
But did you get it back?
Eventually.
Yeah.
Eventually.
But that's not to be deducted from you.
No, not at all.
Right.
I just sent them the receipts and they paid for everything.
Please come to order. We are now on the treaty entitled Agreement between the Government of the Republic of the Philippines and the Partnerships in Environmental Management for the Seas of Southeast Asia, the latter being known by the acronym of PEMC, establishing the PEMC Resource Facility Center. In other words, this is a headquarters agreement between the Philippines and the entity entitled PEMC. Under this, but who is representing Secretary Ramon Paje? Yes. Mr. Secretary, will you please tell us what are the salient features of the headquarters agreement? And particularly, can you explain why we are giving the land away and we're giving facilities and other equipment to this organization of which we are a member? Thank you.
Thank you, Madam Chair. Thank you, Mr. Senator. PEMC started actually, Madam Chair, in 1993 in the Philippines. 1993 po. Always been here. It is the author of the Integrated Coastal Management Methodology. It is the methodology that we used in managing our coastal and marine resources, Madam Chair. In fact, in 2003, the strategy was adopted. And in 2006, the Philippines issued Executive Order number 533, adopting the ICM as the national strategy. And in November 2009, November 26 in particular, the agreement or the capacity of the PEMC as an international legal entity has entered into force. And in July 31, 2012, this agreement was signed by Secretary Del Rosario for the Philippines, and at the time, former Secretary Popo Lutilla as Executive Director of PEMC. And in November 22, 2013, the document was endorsed to the Senate for ratification, Madam Chair. The benefit of this to the Philippines is that this is the methodology and this is the project which helped us all throughout the years in developing particularly the Bay of Batangas, and now it is being used in the following bays or provinces, Your Honors: Aurora, Boracay, Bulacan, Pampanga, Makahalar Bay, Mindoro Oriental, Mindoro Occidental, Marinduque, and Siargao Island. Actually, it is covering more than 8,000 kilometers of our coastline already, approximately 23%. This is the benefit of the Philippines under PEMC. It is actually being supported by a lot of organizations, UNEP, UNDP, IMO, World Bank, and it is being cooperated by around 11 countries, Madam Chair, namely Cambodia, China, DPR Korea, Indonesia, Japan, Laos, Philippines, South Korea, Singapore, Timor-Leste, and Vietnam. The costs, Madam Chair, to the Philippines in hosting this office inside, actually in the Department of Environment and Natural Resources compound, is $42,000 per year. That's the only cost that we incurred, $42,000 per year, Madam Chair. Thank you very much.
Well, apparently our hands are tied. It's been here since 1993. We cannot possibly kick them out. There will be screams of pain from all our partners. And apparently, it has been highly instrumental in the development of our coastline and the management of its resources. Does it pay any taxes under the headquarters agreement? But the officers will enjoy the same privileges and immunities as UN officers. Isn't that so?
The non-Filipino, Your Honor, there are, I think, only 2 and 30 are Filipino. 30 Filipinos and 2 international staff.
How much will it cost to build this facility?
It's already existing.
It's already
Madam Chair.
existing.
Opo. Inside the compound of the Department of Environment.
Oh, I thought you were just assigned a building there for your temporary use, and the building was to be constructed. No, I'm mistaken. It is already constructed there.
It has occupied an existing building, Your Honor.
So this is an ex post facto treaty or instrument. I don't think we're going to spend a lot of time over a building that's already standing there. Well, let's go to the last topic today. Biological diversity, the Nagoya Protocol on access to genetic resources, and the fair and equitable sharing of benefits arising from their utilization to the Convention on Biological Diversity, also known as the Nagoya Convention. Mr. Secretary, at your convenience.
Yes, Madam Chair.
Please proceed.
Madam Chair, thank you for allowing us to present the Nagoya Protocol. Your Honors, thank you for this opportunity to explain why our accession to this international instrument is of paramount strategic importance for the future trajectory development of the Philippines in the 21st century. Biological and genetic resources are an important resource for medicinal and industrial product development. The Philippines is one of the 17 countries endowed with rich biological and genetic resources. Because of these diverse genetic resources, the Philippines has become an important source of biomaterials for commercial product development. In the past, foreign researchers and companies had accessed our biological resources without our knowledge and prior consent. An example of this are the macroorganisms obtained from the soil samples from Panay Island in Davao, which were used for production of antibiotics and epinomycin. These products have been patented in the United States. The Nagoya Protocol is an international instrument that will require users' countries or those which use other biological and genetic resources to ensure compliance with our own national measures on access and benefit sharing. Your Honor, in effect, before we do not benefit from the genetic resources that pharmaceutical companies get from our wildlife resources or biodiversity, Your Honors. But with this agreement, we will start or begin to get share from any medicine or any material or any product that will be developed using the genetic resources of the Philippines, Your Honor. So, as I've mentioned, Your Honor, this has already entered into force last October 12, 2014, and we are recommending that this be adopted, Your Honor.
That we should accede.
Accede,
This is
yeah.
basically to help our indigenous peoples so that they can conserve their natural wealth and earn income if it is utilized by other countries.
Yes, Your Honor, of course, in the entire country, Your Honor.
How are you going to divide the proceeds among 110 indigenous peoples? Do you have a formula for that?
Director Lim, Your Honor, is the head of the Biodiversity Management Bureau, if I may
Yes.
allow.
Madam Chair, at the moment, we're still adopting the Executive Order 247, which allows an agreement to be prepared between the communities and the national government and the interested party, and the benefits should accrue up to the level of the communities. There is no strict formula at the moment, Madam Chair, but we are looking at the being more active in the negotiations.
All right. Name me some products grown locally by our indigenous peoples and used by countries other than the Philippines that have gained some, let us say, some international footing as against pharmaceuticals. What, for example, would this kind of an instrument apply? Is it true, for example, that if you have cancer, you just drink guyabano and you'll get well?
Yes, ma'am. Some of the products that we are developing, because we're also a part of the PTAC, or the Philippine Traditional Health Committee, an alternative medicine committee, and a lot of the products that we are looking at, indigenous herbs, for example, has been developed, or we're looking at developing it for commercial purposes, and some of the plants may come from areas that are within ancestral domains and
what are
within
some of
protected
these
areas.
plants? Tell me. Because we're going out of our way to make sure that they are further refined or processed and then used in the rest of the world.
Yes, ma'am. One example is the lagundi, for example, that we have been developing for cough medicine. The use of the ampalaya, the bitter melon, Madam Chair, we have actually even indigenous ampalaya. There's one that can be found in the north, for example, which is forest dependent. These are small. This is a variety of ampalaya that is found in the forest, and these have all potential for the treatment of diabetes. But we need to be able to make sure that whoever the community that will protect it and the national government as well will be able to get the benefits if this is utilized in other countries for commercial purpose.
Well, I have a more relevant question, but first my whimsical question. Isn't it true that biological medicine might affect the patient in a positive way, but it does it very slowly because the dosages are very small? Whereas if you buy an equivalent from a pharmaceutical company, the effects are faster. So in effect, therefore, pharmaceuticals might still be superior to indigenous materials. What do you say to that?
Yes, ma'am, at the moment, but because there are the other pharmaceutical products, they have access to technologies that allow the processing and the testing of their products. But for the longest time, especially here in the Philippines, our indigenous peoples have been using the certain materials, indigenous materials that can already be developed into medicine. If we can only have the technology to be able to purify the substances that is within this within our indigenous materials, and we also have that potential to be able to increase the efficacy of the medicine that can come from our indigenous.
Baka mamaya pinapayaman lang natin ang mga pharmaceuticals. Under the Convention on Biological Diversity, certain studies were made, and one of the studies showed that if we are to quantify the amount of biological medicine, they would cost $900 billion. Kaya mamaya, if we became a party to the Nagoya Protocol, baka fina-facilitate lang natin na kukunin ng mga Western countries itong ating indigenous, and they will earn the $900 billion. What do you say to that?
Actually, that's what we want to address with the Nagoya Protocol, because it will facilitate the benefit sharing. Although we have already formulated some policies at the national level on access, but it is the benefit sharing that needs to be that needs to be discussed and needs to be refined at the international level, so that it will allow us to have to be more transparent. It will allow us to have transparency in the use of the resources that is coming from us, and then we can demand for the appropriate benefits and the royalties that should accrue to the country, Madam Chair.
So, with this context, we must remember that when we accede to the Nagoya Protocol, we must coordinate with all other developing countries like ourselves. We should not fall into the trap of the evil pharmaceutical companies who make billions of dollars from imagined illnesses that they themselves help to manufacture in the minds of the consumers. That should be our attitude. We should always unite with other developing countries, with indigenous peoples like ours. Senator Marcos? No question from Senator Marcos? Yes, Secretary.
Your Honor, you are perfectly correct, Your Honor, in saying that, because when this was deliberated in Nagoya, Your Honor, I can perfectly remember that that is precisely the demand of developing countries. Because as of now, pharmaceutical companies do not even declare the sources of the genetic resources that they use. But under this protocol, Your Honor, they will now be compelled to declare where they got genetic resources, and what is the efficacy, so that the sharing between the pharmaceutical companies in the source will be will be defined, Your Honor.
Senator Marcos.
Yes, we talk about the benefit sharing. Is there a more specific mathematical formula exactly how that's going to work? Or does it differ, different products, different compounds?
Actually, Your Honor, it will depend on the negotiation of the company in the country. But from now on, they are now compelled to declare. At least they are now compared. They can now say that the medicine that we are developing is coming from Lagundi, and this Lagundi is a species coming from Panay or Ilocos of the Philippines, and therefore that particular state and even the province and the indigenous peoples from that area will now be given share or benefit, royalty in effect. But as of now, Your Honor, they use Lagundi, they use Banaba, they use oregano, and we are not getting any single share from this, Your Honors. In fact, as of now, Your Honor, the UPLB developed a particular fertilizer called mycorrhiza, Your Honor. And this mycorrhiza would allow the plants to grow with only one shot of fertilization. It's actually a fungus that you apply to the seedlings, and then you leave it, and it will be fertilized for life. So this has been developed by UPLB, and we are saying that this must be patented immediately and be recognized under this agreement somehow.
So the arrangement would be that if let's say an international pharmaceutical company comes in and begins contract farming of this product, then it will be up to the contract between the farmers, I suppose, or those that own the land in which the product is being grown, and the pharmaceutical company. But the pharmaceutical company, what Nagoya guarantees is that they must declare that it is coming from that part of the Philippines, or the Philippines rather.
The requirement, Your Honor, is that first they must declare that this study will be using this particular species, and this study will be using this particular genetic resource before they can do contracting with the farmers or with the community or the indigenous peoples. On the basis of that declaration, Your Honor, the Nagoya Protocol will kick in, Your Honor.
Thank you, Madam Chair. I only ask because many of these products actually come from the north. So we will be very interested to see how this entire process develops. Thank you, Madam Chair.
Is there any opposition to the Nagoya Protocol? None. Thank you, ladies and gentlemen. This hearing is adjourned.
I have to learn.
We request the media to take the seats in front so the senator can address you properly.